Hello, my name is Patricia Van Haren. I am a family law attorney and the author of the book, How to File and Survive a Divorce in California. Today, I want to discuss how social media can be used both for you or against you during a family law matter today. When I was divorced over 20 years ago, there was no social media, and this was not considered during a divorce process. However, in recent times, many people use Facebook, Instagram, Twitter, and other forms of social media, and social media has just become a part of our daily life. If you are seeing this video now, the odds are that you're using some type of social media. So you may be wondering, how does social media impact a divorce case? In a divorce case, both parties will be required to submit credible evidence to support their arguments. Many times, this evidence can be obtained simply by accessing someone's social media. There's no expectation of privacy on social media. Therefore, you or your spouse may introduce Facebook or Instagram posts into evidence in your divorce as they pertain to relevant issues. Social media may be used in a litigated spousal support matter. For an example, in a spousal support modification proceeding, the ex-wife may claim that she's unable to work due to a disability. During the course of the litigation, the husband displays photos and demonstrates that the wife is going to the gym, she's traveling, she's able to thoroughly enjoy her life. This would have a negative impact on the wife's claim and a positive impact on the husband's claim. In this case, the court may determine that the former spouse is capable of working and modify the support the way the husband is requesting. Another example of social media is during a child custody matter. In one circumstance, there were allegations of drug and alcohol use, and the parent seeking to modify this custody made many allegations, saying their former spouse was drinking and using drugs around the children. These allegations weren't substantiated, however. Our client was able to prove that their former spouse, the one making the accusations, was in fact having parties in her home with the children home and going out to various bars during the time that she should have been home during her custodial time with the children. In this circumstance, the court found that the parent making the accusations was not credible and ruled in favor of our client. You also want to be careful not to make derogatory statements about your spouse on social media or use social media to air your feelings about the divorce process, especially about the attorneys or the judges involved in the case. These posts can be used to show that you're not reasonable and may negatively impact the way the court views you. Never assume that anything you share on social media is private, and always use caution while posting during your divorce case and often afterwards, especially if you have continuing litigation. If you have any questions, feel free to shoot me over an email or give me a call.